Good evening, friends. Uh, I hope you had a great weekend. Today's topic will be a continuation from the last topic that we discussed. We had discussed FIR and we ended our discussion with its journey, which culminated into the charge sheet after going through the phase of investigation. Now we'll take it from there, and once the police report or the charge sheet or the final report or the final form, as they call it, once it is submitted, what are the pre-trial proceedings or what is actually done by a magistrate, either in the form of inquiry or any other pre-trial procedure, which is necessary for making sure that a fair trial is given to the accused. It, for the purpose of making sure that the government exchequer actually has a less burden on it. So all these objects being kept in mind, the pre-trial procedures, starting with cognizance, which will end in charge. We'll discuss all of that. We also have to keep it in mind at the very outset that what are the stages of a criminal case till investigation is complete, till charge sheet is filed. That will be called investigation. After the charge sheet is filed, till taking of uh, till a charge is framed, that will be called inquiry. And after the charge is framed, the trial begins, and that will actually be called trial. So without wasting time now, we'll start with the presentation. Yes. So as the topic is, it will be a journey from cognizance to charge. We'll go through various provisions dealing with the magistrate's power to take cognizance, and then we'll discuss the power of summoning by the magistrate. From that, we'll discuss the supply of PP or supply of copies, and then if commitment is to be needed because the offense is exclusively triable by the court of sessions, then it will be committed. And after that, if there is no prima facie case made out against the accused, if the magistrate is of the view that there is no grounds for proceeding against the accused, then he shall go ahead and discharge the accused. And if he does not discharge the accused, then there shall be a charge, and with the charge, the trial will actually begin. So as I discussed, that investigation is once complete and the final form is forwarded by the police to a competent magistrate. Now the all important step of taking of cognizance comes into picture. Section 190 talks about cognizance, and in fact, if we actually analyze the provisions of CRPC, there are many times cognizance has been taken up. So also the term charge, but none of them has actually been defined in the CRPC. It generally means the application of a judicial mind, but I believe the proper definition of the cognizance would be as given in R.R. Chari versus State of UP 1951. This is a landmark case. This is a very important case. You please remember that whenever someone says that cognizance means application of judicial mind, I don't believe that's a complete definition. If there is 2 marks allotted for the same, if I am the examiner, I would give 1 mark because that is not actually speaking the correct definition. The correct definition would be application of judicial mind towards inquiry or trial. That means if the magistrate applies its judicial mind to what? To make sure that the a case record or the police report that has come before it is taken a step ahead in favor of inquiry or trial, then that will be cognizance. We'll discuss it in the later stage. Why am I saying that it should be this definition? That will be an all-inclusive definition. That is application of judicial mind towards inquiry or trial, as defined in R.R. Chari versus State of UP. S.K. Sinha versus Videocon International Limited 2008 case, their cognizance was defined as that become aware of. Cognizance, the dictionary meaning of it is become aware of or to take notice of, and it is in respect of law, it will be become aware of by the judiciary or taking notice of by the judiciary in respect of an offense committed by someone or an accused with a view to set the criminal law into motion. So all inclusive definition again would be actually encompassing both the definitions together. That will be application of judicial mind towards inquiry or trial in respect of an offense committed by an accused with a view to set the criminal law into motion. That will be an all-inclusive definition. So after cognizance, the stage of inquiry comes, and then comes trial. So how and when cognizance is taken? Either on police report. You have to remember that there are four sources of taking of cognizance. One is on police report, that is under section 173(2). If the police files a police report, then the magistrate may take cognizance. On a private complaint, if someone approaches the magistrate, if it is a non-cognizable case or a cognizable case, it doesn't matter. If it is a cognizable case, then the private person has to approach the police, and the police will submit the police report, and then the magistrate can take a cognizance. But if it is a private person, then uh, he can still approach the magistrate. Doesn't matter whether it is a cognizable case or a non-cognizable case. In that case, a private complaint will be registered, and after that, on the basis of the private complaint, the cognizance can be taken. The cognizance can also be taken on from a report from any other officer or on his own. So there are four sources. So magistrate can himself register a complaint or register a written note, and on the basis of that, a cognizance can also be taken. So as I discussed, in private complaint, if satisfied, the magistrate, if satisfied, he can himself take cognizance, or if required, he can send the same to the police for investigation under section 156(3). We have already discussed that during the investigation part. And the police will examine the complainant and the other witnesses, and then the police report will be filed before the magistrate, and the magistrate, if satisfied, will take cognizance. And or if magistrate is not satisfied, then he can again go for initial uh, evidence that under section 200 and 202, and then go ahead with taking cognizance. The section says that JMFC or a judicial magistrate first class has the power to take cognizance, but a JMSC or a judicial magistrate second class can also take cognizance if specifically empowered by SCJ. Section 461 says what are the effect of an erroneous cognizance. That means if a magistrate who is not empowered and still he has taken cognizance, either on a police report or on a private complaint, or on its own or from any other officer, what will be the effect of it? Section 461 says if he was not empowered and still he has taken cognizance, either in a police report or on a private complaint, if he has done so in good faith, then it will not vitiate the proceeding. But if on his own, that means 191A or B, either on police report or private complaint, if on that basis the cognizance has been taken, even if it is an erroneous one, if it is done in good faith, then the whole proceeding will not be vitiated. But if it is on the third, that is the 191C, that is from any other officer or on his own, then in that case, if it is erroneous, then it will be declared void. Does not matter if it is in good faith or not. It was also reiterated in this case, Joginder Singh versus State of Punjab, in a 2011 case. Also, we have to know that the Sessions Court cannot take cognizance of any offense unless it is committed to him under section 209 or except when otherwise provided by the code. I'm sorry, I've written court, but it should be code. So the Sessions Court cannot take cognizance unless it is committed to him under section 209 or except when otherwise provided by the code. So at this juncture, the pertinent question would arise that whether a second cognizance by a magistrate is possible. As always, I always keep giving you exercises that we'll discuss at the end of the session. So this is one question that I'm putting to you, that whether a second cognizance can be taken by a magistrate on the same set of facts. When I say a second cognizance, that means on the same set of facts can a second cognizance by a magistrate. This was discussed in Keshav Nateshan versus Madhavan 1984 case. But however, I want you to answer it, and if not, then we'll discuss it at the end of the lecture anyway. And then another question is, suppose there is a private complaint and the magistrate has sent it for investigation by the police under section 156(3), or the police has himself submitted a 173(2) report, or after the magistrate had sent the same under section 156(3), the police submitted a final report, as the case may be. Then on that basis, whether the magistrate is bound to take cognizance. So my second question would be whether the magistrate is bound to take cognizance, though the section uses the term may. Whether does may really mean that he can exercise certain discretion, or he is bound to take a cognizance if the final report is submitted by the police. So in RR Chari, as I discussed, RR Chari versus State of UP, it was again narrated beautifully in this landmark judgment that the court may take cognizance, suggests that it can refuse to take cognizance if no proper or incomplete investigation is there. But then again, they actually closed down the shutter quite drastically by saying that it is a very limited scope, and the court, beyond the examination of the fact that whether it was an incomplete investigation or whether it was an improper investigation, beyond that it cannot go. And if it is a proper investigation and a charge sheet has been submitted, then the court is actually bound to take cognizance of a cognizable offense. It was narrated in AC Agrawal SDM Delhi versus Ramkali 1967 case. Again, we have to know that presence of the accused is not necessary while taking cognizance, nor is he entitled to be heard. Now comes 191A, which says cognizance on a complaint. Here what happens is that the magistrate will actually record evidences under 200 and 202 after taking cognizance, and if he is of the opinion there is prima facie case being made against the accused, then he shall summon the accused under section 204. And if he does not feel that or he is not of the opinion that there is a prima facie case being made against the accused, then he shall dismiss the same under section 203. In a complaint case, whether both summons or warrant procedure can be followed, but we have to know that if it is a complaint case but it's a warrant case, then there is this provision of pre-charge evidence. If some of us were with me for the last few classes, and those who have attended the intricacies of criminal trial when we were discussing the summons case, warrant case, sessions case, summary case, when we discuss the modes of trial, then we must know that there is a pre-charge evidence in warrant cases where it is a complaint and it is not a police report. Otherwise than on a police report, if it is a warrant case, then in that case there shall be a pre-charge evidence. So there are two evidences, two times there are opportunity before the accused to cross-examine the witnesses that come before the court to depose against him. In 191B, or cognizance on a police report, this is actually straightforward. Once 173(2) police report or the final form comes, then the magistrate takes cognizance, and straightforwardly he issues process, that is under section 204, if he is of the opinion that there is sufficient ground to proceed against the accused. Then, depending on whether it's a summons case or a warrant case, the same shall be issued. And that means if it is a summons case, summons is issued. If it is a warrant case, then a warrant is issued. But does not have to be necessarily in that order, because the magistrate, if also is of the opinion that in a warrant case a summon has to be issued, then he can go ahead with that. And in a summons case also a warrant can be issued under section 87. uh, Issue of process does not require a speaking order, but if you dismiss the complaint under section 203, then there is a requirement of a speaking. Now comes the all important another important uh, question, that whether once summon has been issued, whether such summon can be recalled by a magistrate. As we all know that there is no power to review the own order of a by especially by a criminal court, except where it is the High Court is exercising the inherent power. There is no power to review. So uh, the question comes that whether a summon once issued, whether it can be recalled. In K.M. Matthew versus State of Kerala 1991, the Honorable Court is of the opinion that recalling of summons is allowed if there is no case against the accused. But in Adalat Prasad versus Rupla Jindal, which overruled this K. Matthew case, the Supreme Court said that there is no inherent power of the magistrate, and hence the recalling of summon is out of the purview of the jurisdiction of the magistrate, as it is not an interlocutory order, and hence there is no power to recall. Only remedy available in such a case is to approach the High Court under section 482 CRPC. In Pepsi Food Limited versus Special Judicial Magistrate Shahjahanpur, this provision, this ratio residendi was given that summons should be issued vigilantly by a magistrate, and the magistrate has to be very cautious while issuing a summons. And what happens is that generally magistrates are very lenient while issuing summons, and they think there is no such right being violated of the accused, because anyway we are just calling him to appear before the court. It's not like we are putting him behind bars. But then we have to remember that once you summon the accused, he is put on trial. The accused is actually put on trial. So that should be also very vigilantly and very sparingly used. So another important note here is that the summons should only be issued after filing of the list of prosecution witnesses, and it shall be accompanied by a copy of complaint in complaint cases. So these are the requirements of the process. 205, though it is not something that I have to discuss here, but because it is a part of this chapter, let's end it once and for all. Magistrate here can dispense with the personal attendance of the accused if he sees a reason to do so. He can very well dispense with the personal attendance of the accused, and the accused hereby may be allowed to appear through pleader. And the Supreme Court has time and again narrated that when warrants are issued, even then 205 can be allowed, but that power should be used sparingly. But Supreme Court has also laid down that such dispensation of personal attendance should not be allowed at the final stages of trial, like accused statement under section 313 CRPC or pronouncement of judgment as the case. In what cases 205 are generally allowed? In documentary evidences where sentence is only fine. There is also a very wide discretion of the magistrate to allow 205 if there is an old person, sick person, there's a woman involved, a further national lady is involved, daily workers or laborers are at place, because obviously if they have to come to court for a day also, their livelihood will be affected. Busy businessmen who cannot attend court regularly, those persons, public servants, because obviously the public at large will be affected if a public servant is called every other day to appear before the court. In such case, there is a discretion to allow 205. And when it is necessary, the court can direct that he will appear before the court, even if a 205 personal dispensation of personal attendance is in force. 206 is nothing but a special summons in petty cases. Accused may be actually allowed to plead his guilt either through post or through a pleader. We'll not discuss that anyway. Now comes that the fact that once process is issued, if 205 has to be allowed, that has been allowed. Now, if the uh, case in hand is exclusively triable by court of sessions, then what will happen? That it will be committed after though the after actually complying with the provision of 207. 207 provision will be complied first, and then if it is exclusively triable by court of sessions, then it shall be committed to the court of sessions, and if not, then straightforward according to the nature of the trial, whether it is a warrant case or a summons case, whether it was instituted on a police report or otherwise than on a police report, whether such case is a summary case, whatever the case may be, on the basis of that, the trial will commence. Section 207 says that the copies of all the documents that the prosecution relies on, including charge sheet, 161 statements, 164 statements, first information report, and other documents like post-mortem report or any injury report or any such document the prosecution relies on, which are material for the accused to know that what is that he has to meet at the time of inquiry or trial. Thus, all such documents have to be supplied to the accused. The object is, as I said, that it is to give the accused a notice of what he has to meet at the time of inquiry or trial. It was held in Gurbachan Singh versus State of Punjab. Also, in other provision in 238, in a warrant case, also it is the mandatory provision of supplying of copy in under section 207 has been demanded. In Siddharth versus in city of Delhi. So this conundrum actually arises that what if the prosecution actually relies on there might be a situation that police actually, for many reasons, they suppress many documents and only supply the documents that are beneficial for the trial. That means that are beneficial for the prosecution, that will only end in conviction. Such documents are given. For example, police, when police will investigate, if there is a plea of alibi document, that means if there is any such claim by the accused that he was at another place while the crime was being committed, that such document may also be recovered by the investigating agency, but they will always want to suppress it, and they will only file the documents which will be beneficial for the prosecution. So in that case, whether this doctrine of fair disclosure principle, the doctrine of fair disclosure principle says that whatever investigating agency is unearthing during the investigation, those all documents shall be forwarded to the court, and such all documents shall be furnished to the accused, irrespective of the fact that whether it is beneficial or detrimental to the accused. All such documents shall be supplied as specified by the fair disclosure principle, which is an English law doctrine. So in Siddharth versus NCT Delhi, what has been held that whether filed or not, it doesn't matter whether the document has been filed or not, and if prosecution will rely upon it, then copy has to be filed. It is a more conservative approach, which says that if whether it is filed or not, if the prosecution will rely upon it, then the copy has to be filed. So basically, it takes care of the fact that the police cannot hide any document from the accused which will be detrimental to him, but it still lays a blanket on the fact that the police can hide such documents, or the prosecution can hide such documents which will be beneficial for the accused. Okay, so deciding factor here is the documents which have a bearing on the case. That was held in Siddharth versus. But DK Shashikala versus State actually went a step further, and it says that even if it is not relied upon, if it is forwarded to the court, then it has to be supplied. So it is saying that even though it is not being relied upon, if it is forwarded to the court, it has to be supplied. But then again, it is not meeting the fair disclosure principle, as I discussed with you. Fair disclosure principle demands that all documents that are unearthed by the investigating agency must be supplied to the accused, even though it is detrimental, even though it is beneficial for the accused, it does not matter. But both the cases, though somehow lay down the jurisprudence of supply of copy of documents, does not meet the criteria that the fair disclosure principle demands. Okay, so but the section here demands that all the documents that have been forwarded to the court and those who have a bearing on the case, especially detrimental to the accused, all such documents have to be furnished. And if such illegality of non-furnishing of documents which are detrimental to the accused and will be used by prosecution is not supplied, then it shall be an illegal. Section 208 says that if case instituted otherwise than in a police report, then the magistrate to supply statement under section 200, 202, 161, 164 or any other documents as the case may be. So 208, 207, when it talks about the supply of copy by the police, well, when filing of a police report, by the police I mean when a police report has been filed, the supplying of copies. Here it's a complaint, so no question of police report. Here the magistrate will supply the 200 statement, 202 statement, 161, 164. If the magistrate, how you may ask here that if it is a complaint, then how is the possible? How is it possible that 161 or 164 statements will be recorded? Yes, it can be, because the magistrate may direct the police under section 156(3) to investigate, and if the police submits a police report on the basis of that, then there is a possibility that 161, 164 may be recorded. In such case, all such documents have to be supplied to the accused. Now comes 209, that if it is exclusively triable by the Court of Sessions, then all the documents along with the case record and the accused will be committed to the Sessions Court, and the PP will be notified to appear before the Sessions Court to continue the trial there. Here, the power of the magistrate is a discretion. We have to know that if the police submits a police report claiming that 307 has been committed, but the magistrate, after perusal of the case record, is of the view that at the stage of taking cognizance, is of the view that 325 is only being made out, then he is not bound to just forward the police report because of the fact that the police report suggests that the offences are exclusively triable by Court of Sessions. Okay, so he finds that it is triable by Court of Sessions, and then he must commit it to the Sessions Court. Here, the presence of accused is not mandatory, but if he is not present, the irregularity is a curable one under section 465. So basically, the irregularity of the accused not being present will not vitiate the trial altogether. Here, the magistrate has no power to discharge or drop the case. So if it is a case exclusively triable by Court of Sessions, even then the magistrate has no power to drop the case or discharge the case, as the case may be. For that reason, here, even if a final report, I mean a negative final form, that is, the police says that no, we investigated but we did not find any offense to be committed, even then the magistrate has no power to discharge or drop the case, as held in Sanjay Gandhi versus Union of India. It is the Sessions Court who is the proper court who will do all of that. Now, once the matter is committed to the Court of Sessions, 193 prescribes a second cognizance of the offence by the Sessions Court. As we all know that cognizance is taken only once. We all may be of the view that cognizance is taken only once. After the magistrate has applied its mind, it becomes a functus officio, and there cannot be a second cognizance. But once it is committed to the Sessions Court, a second cognizance of the offence by the Sessions Court at this stage can be done. We have to remember, though, that there is no original jurisdiction of the Sessions Court to take cognizance if it is only where it is committed to it, or a case is committed to it because it was exclusively triable by court of sessions by magistrate, or he is specifically provided in the court, as we'll discuss in the cases of defamation in certain cases and otherwise. In such cases only he has original jurisdiction. Otherwise, there is no original jurisdiction of the sessions court to take cognizance. Also, uh, if it is provided by any other law like SC/ST Act, NDPS Act, then also the sessions court can take cognizance. POCSO Act, for that matter, there are many acts for which there can be original jurisdiction of taking cognizance by the sessions court. Commitment is of the case and not of the accused. So this is one question which arises always, that whether the sessions court at the stage of taking second cognizance can add another accused. So the question was answered in affirmative in Joginder versus State, where it was held that commitment is of the case and not of the accused, and hence even after commitment other accused persons can be added. And once the case is committed, it provides with unfettered jurisdiction to sessions court, as restriction on original jurisdiction to take cognizance is lifted by virtue of such commitment. Now, other incidental provisions, which is 191, that is transfer and application of accused if magistrate has taken cognizance under section 191C. So here, if the magistrate on his own has initiated a case, then the accused has to be informed that he has a right to be tried by another court. The accused has to be informed that, so specifically in 191C, not in 191B, A or A. Here, because the magistrate himself has been the complainant, or on the basis of the written note of the magistrate himself, the case has commenced. In such a case, he has to inform the accused that, listen, because I am the complainant here, or I have initiated the case against you, you have a right to, as per the principle of natural justice, you can demand that there can be a different court in which your case will be tried. If this right is not informed to the accused, then that will vitiate the trial, and the illegality is not curable under section 465. As I discussed, that it is nothing but to honor the object of principle of natural justice. 192 is nothing but a provision which enables a cog-taking magistrate to make over the cases to other magistrates. The 192 says that CJ or other magistrate who have taken cognizance can make over the cases to other magistrate, which is a deviation from the normal rule that whoever takes a cognizance must try it. In Odisha, specifically SDJM or other cog-taking or cognizance-taking courts, as they call it, they are specifically empowered to take cognizance, and they may make over the cases to other magistrates for trial. Now, this vast gamut of provisions are there, which provides limitation over taking cognizance. These are not something that which are very important for the examination, may be important for the scheme of short objective type questions. So you may just go through this page, that is 194, 195, 196, 197, 198. All these provisions are talking about limitations over taking cognizance, that when cognizance shall not be taken. Okay, so 194 says that additional and additional session judges. This is not under that, probably it has been by mistake it has come under it. 194 is a separate provision which says that additional and assistant session judges can try the cases made over to them for proper distribution of work. So session judge can make over the cases to additional session judge and assistant session judge to make sure that there is an equitable distribution of the work. So now I'll discuss the limitations over taking cognizance. I'll not discuss, I'll just go through them once. 195 says that offences involving contempt of lawful authority of public servant, the cognizance cannot be taken except on written complaint of the concerned public servant. So basically, when cognizance shall not be taken, these have been laid down here. This is not something that I'll discuss. It will be wastage of time. You please go through it. here certain things that you must know, that who is a public servant, or what is an official discharge or discharge of official duty. All these elements, please go through them. If there is any doubt, we can discuss them later. Mm, yes, another important element that you have to know, that section 468(2) also prescribes a limitation period. If the cognizance within which is not taken, then that is barred. So these are the limitations over taking cognizance power by a magistrate. Now 210 is amalgamation of proceeding. So it talks about, if so the case here is that there is a FIR pending, there is an FIR pending, and a complaint is filed in respect of the same set of facts. Then what will be done here? The complaint will be stayed, and after the police report in the FIR is filed, those two will be clubbed. It is also vice versa. So if that way, if FIR is filed, FIR is brought when a complaint is already sub judice, in that case also the magistrate can uh, make sure that those are joined together, and then those are tried together. Make sure to make just to make sure that the accused is not harassed twice, the anomalies are avoided, and the private complaint will not usually interfere in the police report or the uh, public complaint, as the case. So after this miscellaneous provision, will again move to our topic. So I am discussing all these provision because these are there in the chapter. But for the sake of convenience, let me tell you one thing, that after 190 or of cognizance is taken, 204 issue of process, that is coming under this particular chapter, which is linked with the process of pre-trial procedure, and then 205, and then 207 supply of copy, and then if it is a sessions tribal case, 209, then 193 cognizance by second time, the sessions court will take a cognizance. 191, 192 are having certain relevance, and then comes 227. 227 is discharge. So after making sure that the uh, sessions tribal cases are committed, if they are not committed, then supplying of copy has already been done. So at this stage, the court has to basically two options: either to discharge the accused, or charge the accused if he does not discharge him. So under section 227, it prescribes that in a sessions tribal case, when the accused will be discharged. So it says that the discharge of the accused can be done if there are no sufficient grounds for proceeding against the accused, after considering the case and hearing the rival parties, and after recording reasons. Then, if the sessions court is of the opinion that there is no ground for sufficient ground for proceeding against the accused, then he may discharge. But here, the important question is that when will the accused actually be discharged? So what is the deciding factor here? In Union of India versus PK Samal, it was made clear that here the object behind discharge, or while discharging, the sessions court must ensure that whether a prima facie case is made out against the accused on reading all the materials that are before it. So on the bare reading of all the materials before it and hearing the rival parties once, if the sessions court is of the opinion that there is no ground for proceeding against the accused, because there is only a suspicion and there is not a grave suspicion, then in that case, if it is a grave suspicion, then he shall go ahead and charge the accused. And if it's a suspicion only, because there are two views possible. One view says that there are a set of evidences which is saying that the accused has probably committed the crime, and which is say another set of evidences on the same set of facts which says that there is a probability that accused has not committed the crime. then they may proceed accordingly. In Dilawar versus State of Maharashtra, it was made more clear. In this case, UI versus PKF Samal, it was probably a bit dicey. In Dilawar versus State of Maharashtra, it was made clear that while hearing the question of discharge, not to conduct the sessions judge not to conduct a detailed inquiry, and if two views were equally possible on the basis of the documents before it, then it shall not be a grave suspicion, and the court can do well to discharge the accused. So the deciding factor here is whether there is a grave suspicion or a mere suspicion. Again the very important question comes that whether the accused can place any document, because the section said that after considering the case and hearing the rival parties. So that means it is limiting it to these two things, that is case before it and hearing the rival parties. So the question here is whether accused can place a document or any evidence just to make sure that he will be discharged. In Satish Mehra versus State of Delhi, 1996, it was said that if the material is conclusive enough, then it can be looked into. That means if whatever material the accused is furnishing, if that is of such a nature that will conclusively make sure that it will give a presumption in the mind of the court that there is no sufficient ground for proceeding against the accused, then the court can do well to discharge him. But in State of Odisha versus Devendranath Padi 2005, the principle was limited and it was diluted, as the Honorable Supreme Court held that while discharging or while hearing the question of discharge, the court is confined to the prosecution case only and the case record before it, and not any other documents that can be placed before the court by the accused. However, in Romani Navekar versus Vijaya, H. Verma versus State, and Neeta Dharmendra versus Gopal Reddy, these conservative view of the Honorable Supreme Court that it will only be limited to prosecution case and the case record was somehow diluted again by laying down that if it is a conclusive material, then it can be looked into. If it is an unimpeachable material, then if it is going in the favor of the accused, then it can be looked into, and materials of sterling quality by the accused can also be looked into at the stage of charge or discharge, as the case may be. Now again, all these terms which were used by the Honorable Supreme Court, that is conclusive, unimpeachable, and sterling quality, these are very subjective, and how far it will actually guide the trial courts, it is still to be looked into. Again, as I discussed, 227 and 239 in discharge provision is also there. So in warrant cases instituted on police report, if the materials before the court are groundless, here it is used that the materials before are groundless. There in 227 it was there that no sufficient ground for proceeding against the accused. Here it is saying that the materials before are groundless, then he can discharge it. In 245, in warrant cases on complaint, also there is warrant cases on complaint that is not on police report. In such cases also, there is a provision of discharge after recording the evidences and taking the materials on record. The court is of the view that there is no prima facie case being made out against the accused and there is no ground to proceed against the accused, then the accused can be discharged as well. So and the case laws that we discussed previously, that Satish Mehra, State of Odisha versus Devendranath Padi, Romani Navekar versus Vijaya, H. Verma versus State, Neeta Dharmendra versus Gopal Reddy, hold good for warrant cases and otherwise as well. Now we'll discuss section 251. In summons cases, there is no provision for formal charge. So here there is only substance of accusation is explained to the accused, and there is no provision of discharge. So here accused is asked whether he pleads guilty or whether he has any defense to make. So where when there is no provision of making a discharge, the question comes that what is the remedy available to the accused at this stage? So in K. Matthew versus State of Kerala, it was held that though there is no power to uh, discharge the accused, still if summons has been issued and the magistrate is of the opinion at this stage that there is no ground to proceed against the accused, then the summon can be recalled. Though there is no usage of the term discharge, the summon can be recalled. But in Adalat Prasad versus Rupal Jindal, as we have discussed previously, that it is not an interlocutory order, so no inherent power of the magistrate, and hence a summon once issued cannot be recalled. And the only remedy available here is to approach the High Court under Section 482, and the High Court can definitely entertain or the recalling of summon petition. After this, once it is clear that the accused will not be discharged, the magistrate will go ahead with charge. 228, 240, 246, and 251, as the case may be, they discuss with framing of charge or the substantive accusation to be stated, as the case may be. 228 says that if finds ground to proceed against him, then he can either revert the case back to lower courts for trial if lesser crime found, or if exclusively triable by court of sessions, then frame charge in writing, and which shall be read and explained to the accused, and he shall be asked whether he pleads guilty or claims to be tried. 240, which is a warrant case on police report, it says that if presumption that there is ground for proceeding against the accused, then the magistrate is empowered enough to try and punish, then he shall frame charge in writing and read and explain to the accused, and he shall be asked if he pleads guilty. In 246, that is in warrant cases, otherwise than on a police report, that is on a complaint, then if presumption that there is ground for proceeding against the accused and the magistrate is empowered enough to try and adequately punish, then he shall frame charge in writing, etc. 251, though there is no provision of charge or discharge, the substance of accusation are to be stated when the accused is brought, and then the proceeding will commence. So my duty is to remind you that between cognizance and charge, it is inquiry, as held in Common Cause versus Union of India 1976. That trial commences only after framing of charge. That is, that was also reiterated in Hardeep Singh versus State of Punjab. That when does the trial commence? After this section. That is after 228 charge framed in sessions cases, 240 or 246 as the case may be in warrant cases, 251 substance of accusation stated to the accused in a summons case. Now comes framing of charge. Before framing of charge, our duty is to find out whether there is a definition, and there is no definition for charge found anywhere in the CRPC except 2B, which says that charge includes any head of charge when charge contains more heads than one. It is nothing but a circular definition. That means a definition which includes the term which is trying to be defined, which is actually being tried to be defined. So in that case, there is no proper definition, but for the sake of your knowledge, you should know that it is a specific formulation of accusation made to the accused with an object of enabling him to know the case against him and prepare his defense. So it is nothing but a specific formulation of accusation made to the accused. So obviously the specific formulation accusations should be made to the accused, which were against him, just to let him know that what is his case, and so that he will be enabled to prepare his defense. Now we'll discuss what are the contents of the charge as laid down in 211, 212, and 230. 211 says that offenses with which he is charged, name given by law. If there is a name given by law, that is, the offense is described by such one name, that is, if murder, then it shall be described by that name only, that is, murder will be written. If no specific name given to that offense, then the offense shall be described in a manner which will give notice to the accused of the matter that has taken place. Law and section of law are also to be mentioned under 211. Again, what are to be mentioned? That every legal condition fulfilled to constitute an offense must be stated. That means if intention is material in a commission of offense, that is, while deciding that whether an offense is committed, intention is material or general exceptions is material, then those are to be uh, stated specifically. So for that matter, if without grave and provocation I committed this, I mean you commit in a charge, it should be written that without grave and sudden provocation you committed this, or you intentionally committed this. So the legal condition required to fulfill or constitute an offense, they should be explained as well. Next is that it should be in the language of the court. So in section 272, it has been written what will be the language of the court that will be decided by the state government. Previous conviction, if it is proved, then the charge must contain that as well, that there was a previous conviction made against the accused, that will be written as well. Again, person against whom committed, that will be written as well. Then place, time, and particular of the offense, that will be written. Thing, if in respect of something the offense is committed, then that shall be written as well. If within 1 year there is a criminal breach of trust or a misappropriation of property, then gross sum or description of movable property and dates uh, between period and dates between which it has been committed, then if it has been mentioned, then that will be sufficient. And another thing that has to be mentioned is that if particulars are not enough, then the manner in which the alleged offense was committed, they shall be given. So, for example, in a case of cheating, it shall also be written that you in this manner cheated X. So that has to be written as well. 214 is nothing but a rule of interpretation which says that if there is a word used in charge, then that shall be given the same meaning as prescribed to them under the law. That is, if in IPC a murder has been defined, if the word murder is used, then that shall be given the same meaning. 215 talks about the effect of an erroneous charge. That is, if the accused is misled by such erroneous charge and there results a miscarriage of justice, then it will be a material defect and the entire trial may be vitiated. Under section 464, if it is a material defect because has resulted in a miscarriage of justice because of the erroneous charge, then it will be fatal to the case. So instead of West Bengal versus Ansar Sheikh, the deciding factor was decided that the accused has to be prejudiced or misled. That is a mandatory requirement to make sure that on the basis of erroneous charge, the trial can be vitiated or not. 216 talks about that whether the court can alter any charge, and 216 says that court can alter a charge or add to any charge any time before judgment. Any time before judgment, when I say that, that means the question can come that whether an appellate court can alter a charge. This question I put to you again. That I'm saying that in under 216 the court can alter a charge or add to any charge any time before judgment, but not to the prejudice of the accused. That means before judgment the court can alter a charge or add to any charge. So that means whether in an appellate court or a sessions court, while hearing the appeal, can he alter a charge? Please answer me at the end of the session. Again, the deciding factor is here should be that if prejudice is the accused, then certain step has to be followed. That is, under 217, he will be given an option to recall the witness, and if it is causing no prejudice, then it can be altered or it can be added very easily. If it is causing any prejudice, then under 217 he'll be given another chance to recall the witness. Another question I put here is, please someone, I hope everyone is noting down the question that I'm putting, because these are of very vital importance and I want to discuss them, but then I want you to exercise your mind as well. That's the reason I'm putting them to you. Another question is that can charge be framed in summons cases? Can charge be framed in summons cases? Please answer me that question. Another question that I put here before this was that whether sessions court or an appellate court can alter or add to any charge. Now, what are the procedure for alteration or addition of charge? That shall be read and explained to the accused. If there is no change in proceeding, then straightforward you go ahead with the trial. But if there is any prejudice to any party or there is any change of proceeding, for example, the previous charge was 325, so it was a triable by magistrate, but now I am altering the charge to 307. So that means it is triable by court of sessions. Here proceeding will change. Then either here there are two courts, either adjourn the case and then commit, or there will be a new trial or a de novo trial altogether. Next is, if there is a change charge and the charge which is formulated at the later stage needs sanction of any authority or government, because we did not discuss then, but then I told you that you should go through all of this, these provisions, 194, 195, 196, 197, 198, all these demands certain sanction from, like in 197 it says that offenses committed by judge or public servant acting in discharge of official duty, cognizance cannot be taken except to the previous sanction of the appropriate one. In judiciary, in fact, there has been a stricter mechanism of making sure that when an offense committed by a judge is to be uh, taken cognizance of, in fact, at the stage of FIR itself, if it is a normal judicial officer, then the permission of the district judge has to be obtained. If it is a district judge, then the permission of the high court judges, either the portfolio judge or the chief justice, as the case may be, that has to be obtained. So there are certain sanctions prescribed. So my point was that while if it is a change charge, then if it needs sanction, then shall not proceed until the sanction is obtained. If after trial, if once the trial has commenced and then you want to alter the charge, then the recalling or resummoning of the witnesses shall be allowed unless considered vexatious or just to cause delay or to cause miscarriage of justice by the court. But the court has to record reasons for not allowing such recall or resummoning witness prayer made by the party who is affected by it. 218 says that distinct charge for distinct offenses and every charge must be tried separately. So that is the rule, that all there shall be a distinct charge for distinct offenses and every charge must be tried separately. The object behind this is that the magistrate or the court, while trying the same, will not be prejudiced, thinking to consideration, oh, there are so many charges against the accused, there must be something he has committed, otherwise why is there so many charges against him? So all those charges must be tried separately. That is the object behind it. But except if accused himself says that I want that all the charges should be tried together, in that case all the charges can be tried together as well. 219 says that 3 offenses of same kind committed in 1 year, committed within 12 months or 1 year, they can be charged together. So that means within a period of 1 year, if there are offenses of similar kind, same kind as in, well, that means similar kind, if they are committed within 1 year, then those can be tried together. When I say can be, it's an enabling provision. And what is an enabling provision? That means even if we do not follow this, even if there is a failure to follow this particular rule, the trial will not be vitiated just because it was not followed. But if it is a mandatory provision, then it has to be followed. In an enabling provision, it is just for the sake of convenience that there are 3 offenses committed within the same 1 year, then they can be charged together. 220 says that if there are more than 1 offenses committed as part of one transaction, then they can be tried together. So it is saying that if there are more than one offenses committed as part of one transaction, that is, while while a person was uh, a person was driving a car rashly, killed X at Kanika Chowk, and then killed Y at Satichora Chowk, and then rushed to CDA and also broke a certain house, uh, or and then probably fled this spot. So if this is the same transaction, even if more than one offenses have been committed here, such offenses can be tried together. Another thing given here is that if there is a misappropriation of property or a breach of trust, then they can be tried along with the offense for falsification of accounts, because these are analogous, because these are cognate offenses, as I call it. Cognate means that offenses of similar kind, if there are offenses like that, then they should be tried together for the sake of convenience. Now, another thing given under 220 is offenses falling under two definitions can also be tried together. So basically, if there are two definitions possible for an offense, there are two contradictory offenses, but falling under two definitions, then they can be also tried together. And next is offenses combined constituting different offenses, they can also be tried together. That means there are two offenses which are offenses while they are dealt with individually, but when they are combined, they constitute another offense altogether. For example, 394 is equal to 323 plus 392. So 323 is an independent offense, 392 is an independent offense, but if both of them are combined, they make 394. So uh, the normal science student may say 323 plus 392 will be 700 something, but your answer should be 394. So here, if there are different offenses which can be tried together and combinedly constitute different offenses, then they can be tried together. Section 221 says that acts which cause doubt as to what offenses are committed, then they can be tried together as well after charging them with all or an alternate. Applies in cognate offenses, I've written here. That means offenses of similar kind. Because suppose, for example, I'll give you an example to make it clear that there is an allegation that a stolen property has been recovered from X. So either he has committed theft, or he has received the stolen property, or he has helped someone in obtaining the stolen property, whatever the case may be. So these are analogous offenses. So in such cases, all such offenses, because there is a doubt that which offense is actually committed, such offenses can be tried together, and the accused can later be convicted in any one of them as the case. Section 222 is a very important provision again, but then we have somehow discussed in 220 last part. 222 says that if the accused is being tried for an offense, the several particulars of which are minor offenses, and some part is not proved, but the rest is proved, or certain facts reduce it to a minor offense, then he can be convicted for the minor offense. Right? So the point here is that there is a major offense, and the several particulars of which are minor offenses. The earlier example that I gave holds good here. 394 is the major offense. The several particulars of that are voluntarily causing hurt, also robbery. 392, 323. Both of them are minor offenses. Minor offenses, that means obviously they are subsidiary to it. They are together making a major offense. So that way it's a minor offense. So if some part, that means if 323 now is not made out, then only 392 will be, he'll be convicted only under 392, right? If 392 is not made out, then he'll only be convicted under 323. Suppose it is proved that he had not taken the gold chain, then 323 only he can be convicted. Also, the third proviso says that If he is charged with an offense, then he can be convicted for its attempt. So of course, it is a very basic provision which says that suppose allegation of theft is there, and now the uh, accused is saying that I have not committed the theft because I don't have the property with me. You can check, it is still with the X. But the X was alleging that yes, he was trying to insert his hand in my pocket and take the uh, property. So in that case, he can be convicted for its attempt as well. Now comes section 223, which is joinder of charges against more than one accused in same crime. So it says that if there is same offense, same transaction, more than one accused, then they can be tried together. Same offense, offense. One person is committing an offense, another person is committing the attempt of thereof, and another person is committing the abatement thereof. Then all three persons also can be tried together. Again, more than one offense of same kind committed by persons, more than one persons within 12 months, 12 years, I've written 12 months. Then in that case also, the joinder of charges for more than one persons can be done. Different offenses in same transaction. As I said, we are an unlawful assembly. While going, we torched a house on fire, then killed someone, then robbed his house. So there are different offenses committed, which is a part of the same transaction. In that case also, joinder of charge can be done. Now another thing is offenses which are consequence offenses, and the offenses which are consequential offenses or incidental offenses thereof. For example, theft, receiver of stolen property. Uh, for example, all these kinds of offenses, or attempt or to counterfeit coins, and then abatement to counterfeit coins, and the offense of counterfeiting coins. They can be tried together. All these are there. 224 talks about withdrawal of charges on conviction on one of the several charges in a trial to have the same effect as that of acquittal. So it says that if there is a charge, there are charges, several charges, and on some of the charges there is a conviction, and on other charges there is no such conviction, then all such charges can be withdrawn at the request of the prosecution, and the same shall have the effect of the acquittal. Now, what is the effect of misjoinder? That it will not be fatal and it can be cured under section 464, but if amounts to failure of justice, will be vitiated. So basically, misjoinder will not be fatal and can be cured, but should not amount to failure of justice. That is held in Willie Stanley versus State of California. With this, we somehow end our discussion relating to cognizance, the journey from cognizance to charge. I hope I was clear. If there are any doubts, you may place them at this stage.
Good evening, sir. So you had asked a question while your session, conducting your session, that whether the appellate court can alter the charge.
Yes.
So in my view, sir, as an appeal is a continuation of a proceeding, wherein again the entire proceeding are left open for the appellate authorities for a reconsideration. Therefore, in my view, the appellate court has also the power to alter the charges.
Absolutely, absolutely. Appeal is nothing but a continuation of the trial. You may find through various Supreme Court judgments that appeal is nothing but a continuation of the trial, because the trial was commenced. Some party was not happy with it. They actually wanted to appeal against it. Now that it is going on, it is nothing but a continuation of the trial. So if during the trial at any stage the charge can be altered or added, then during the appeal, till the final appeal is done and the limitation thereof expires, I believe there is a scope of altering the charge or adding a new charge.
Sir,
Any
good evening,
other
sir.
question? Yes, Asif.
Sir, I want to say that once the charges are framed, can the accused be discharged in the general provision or in case of compounding of offense?
In the case of compounding of offenses,
Yes.
so
Generally, once the charges are framed, the person has not.
there it is in the compounding offense. It is written that it shall have an effect of discharge. That is that what you're trying to say?
This is the effect of discharge, but generally, what happens? Normally, in practical
Generally,
cases,
generally in practical cases, what happens is that at the outset, when the summons is issued and the accused is brought, then he will there will be brought or produced. In that case, either there shall be a discharge petition filed. If there is no discharge petition filed, then the court actually go ahead with the framing of charge. If there is a discharge petition, then it shall be heard then, and on the very same day, the accused should be charged. If they do not want to discharge, or if they wants to, I mean they want to discharge, in that case, he should be discharged forthwith as well. That's the practical thing.
once the charges are framed, he cannot be acquitted. Means I mean he cannot be discharged.
Discharge, yes. Once the charge is framed, then the trial commences. After the trial commences, he cannot be discharged because the charge has already been framed.
Okay, thank you.
Okay. Snigdha Panigrahi writes that in a summons case, the material particulars can be explained to the accused, and it is not necessary to frame a formal charge. I believe it's a statement, uh, not a question. Yes, it's a correct statement, but not a question, nevertheless. Anyway, anyone has any other questions? Please go ahead. I asked 3 core questions. Why aren't
Good evening,
you
sir.
answering? Yes, good evening.
Sir, I have a doubt regarding section 209 CRPC
Yes, what is it?
regarding committal procedure.
Yes.
I would like to read out one sentence from section 209.
Hmm.
That is, when in a case instituted on a police report or otherwise, the accused appears or is brought before the magistrate. Therefore, it's a pre-trial procedure. Sir, what if the magistrate later finds out that the case is exclusively triable by court of session? That is during the trial. What will be the procedure then?
See, there is a when I to put simply, there is a specific provision laid down in CRPC under section 323. I probably forgot to discuss that. It's my bad. 323 should be read in consonance with 3209 because there appears many times. I have actually faced such conundrums in my court while trying. I have come to the conclusion that this is not an offense that should be tried by me. In that case, what will be the consequence? 323 prescribes that in while a trial is going on, that means after the uh, 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 pre-trial procedure has ended and after charge has been framed, so trial has begun. In that case also, while the magistrate is trying, if he finds that this case is not to be tried by this court and this should be sent to the a sessions court which has the power to exclusively try such cases, then it should be sent. 323 makes such provision, and it will have the effect as if under 209 it has been committed to the sessions court. For example, there might be a case that during the trial 354 case has come, but during the trial the prosecutrix or the victim says that he did certain things which may amount to rape right now, and now as a magistrate, the magistrate cannot try the same because of lack of jurisdiction. Then he should not be barred, and the CRPC in fact has taken care of that, and 323 CRPC has uh, made sure that you can commit the same to the sessions court. Anyone else has any other doubt?
Sir, hello.
Yes.
Uh,
Yes,
Sir,
Sivasis.
what are the remedies available to the person? Means what are the remedies available to the UTP against whom police has submitted the negative charge sheet, that is final report.
If the final report has been submitted and the accused, then the magistrate will, if it is not a sessions case, if it is not a case exclusively triable by court of sessions, then the magistrate will call for the uh, informant, that is the person who has registered the FIR on the basis of which the case has started, or the victims. And if they come and if they say that they do not have any objection if the case is dropped, and then the magistrate can very well go ahead and drop the case. And in that case, the person who is in custody, he shall be released forthwith. If it is a case tribal by court of sessions, and then in that case, the magistrate has no option to discharge or drop the proceeding. So he shall send it to the sessions court along with the final report, even if it is a final report, if it is a negative report. I am glad that you call it a final report, because most of the people, they call it either final, they call it police report only. You have to use this particular words, that if it is a negative, if it is a general term, you use final term. If it is a negative, final report. If it is a positive, that is a charge sheet. So these are the remedies as we discussed.
Thank you, sir.
Welcome. Limitation for taking cognizance of offences. That are you asking about the period of limitation, or you are asking about the 194, 195 other provisions that we
The
discussed?
period of limitation.
What is it? What is it?
The period of limitation.
Period of limitation, we'll take it in another class. So we'll discuss it. We'll discuss it. Do not worry. We'll actually discuss it along with. I hope when we are discussing appeal revision reference, in that chapter we'll discuss the limitation as well. So I'll make sure that that part is taken care
Yes, sir.
of. Okay.
Sir,
Yes.
hello. Sir,
Devashish,
you have
yes.
asked a question that can charge be framed against summons cases, summons
In
cases.
some cases. In some cases, yes.
In
Some
summons
cases.
cases. So I think there is no need to frame charge in summons cases in general. So because 251 says it shall not be necessary to frame a formal charge, but the substance of accusation to be stated to the accused.
Right.
But if 259 CRPC says if the punishment is more than 6 months, the magistrate can convert it into the warrant cases and try it accordingly. Then in that case, the magistrate can frame charge.
Absolutely. That was a clever answer. I'm glad that you could think that way. Yes, in summons cases, that provision is also there, that you can uh, frame a charge because it was converted into a warrant case. Also, for that matter, there is no bar. It has been held by many many decisions, that there is no bar anywhere for framing of charge. The substance of accusation is to be stated. It is true. It has been prescribed. There is no need of framing charge. When they say that there is no need of framing charge, it does not mean that you cannot frame a charge. You still can frame a charge if you believe that the charge would serve better interest of the accused, because all the provisions in CRPC are accused centric. They are laid down to make sure that we reach to a fair conclusion or a fair trial, fair, justice, with the fact that the accused feels at home. Doesn't mean, I do not mean to say that you have to make him feel home, but that means that he does not think that all these people are conspiring together to put me behind bars. That should be the aim of a fair criminal trial. He should know that even if the world is against him, the court there is not in. If even if it is not in my side, at least he is not against. He'll make sure that justice will prevail. Right. So that way, even if it's a summons case, the charge framing is not actually a bad way to go.
Thank you, sir.
Court is not taking cognizance on the ground or plea of waiting for sanction. I couldn't get the question, Sakti. Can you narrate it to me? Can you explain it to me? Again, anyone has other doubts? The magistrate, without having territorial jurisdiction, has taken cognizance. Is there any impact or effect on trial? Yes. So the question is again. Uh, it's a pertinent question. The fact that the police can also investigate outside its jurisdiction also in certain manner gives rise to the idea that the magistrate can also exercise its jurisdiction without outside its territorial jurisdiction. But then that doesn't mean that the magistrate will in all cases take cognizance of the cases outside its territorial jurisdiction. But for example, in a case the magistrate has taken a cognizance of an offense which was outside his territorial jurisdiction, then just because the magistrate was not competent to take cognizance of the fact, cognizance of the matter, on that basis only, it will not be a bad trial, or the trial shall not be vitiated just because of it. But ordinarily, the magistrate should always refrain from taking cognizance of a matter which is outside of the territorial jurisdiction of his court. Pratap Sahu puts a question that if a lower court, without providing necessary copies like FIR 161, 164 reports, commit a case to Sessions Court, can the Sessions Court provide the same after taking cognizance? I believe non-supplying of copies is a material irregularity, and that, in fact, as we discussed, let's just go back to the provision. It's a material irregularity. It's not an irregularity, in fact, it's an illegality. It's not an irregularity that it can be cured, it's an illegality, because all the documents have to be supplied before the case is committed to the Sessions Court. So non-supplying of copies, if it has not been supplied, then in that case, then it will be actually having the effect of an illegal thing that has been committed. Nevertheless, your question is whether Sessions Court can supply it. Yes, definitely the Sessions Court will at that stage supply, but the magistrate will be held accountable for the reason he has not supplied the copies before committing the same to the Sessions Court. Is a defective charge necessary? Yes, thank you. Is a defective charge necessarily fatal to the conviction? No, not necessarily. But if a defective charge is in the nature of the fact that it is prejudicing the accused, or it is making sure that the accused was actually misinformed, or he was actually misled by such erroneous or defective charge. For example, I'll give an example. There is a beautiful example given in CRPC itself. I'll probably state that example to rest this particular question. That is, suppose the magistrate, what is the procedure? What is the way a charge is actually pronounced? That I, name of the PO and the designation thereof, hereby charge you with such and such, that you on this date, uh, that you on this date, at this time, at this place, committed this offense in this manner, and thereby liable to be punished under section dash of IPC. And I direct that you shall be tried accordingly. So this is the format of the charge, more or less. So in such a case, if for that matter, a charge is framed in which uh, the accused is said that you have committed murder of uh, Sachin Tendulkar. You have committed murder of Sachin Tendulkar. I don't remember the name that was used, so I'm using any random name because I'm a cricket fan anyway. So basically, I am accusing someone that you have committed the murder of Sachin Tendulkar on 20th of January 2020. But actually, he has the murder which was alleged was of Sachin Tichkule or another person and on another date altogether. In such case, if the accused is only facing that offense, I mean that is the only murder he has ever been charged with. In such a case, there is no material irregularity, and such defective charge will not be fatal, because he cannot say that, oh, you said Sachin Tendulkar and that's why I could not. Obviously there is one murder that you have been charged with. Even if there is there is a defective charge because the name was mispronounced, or the date was also misstated. In that case also, such defective charge will not be fatal, because there was only. But for example, the some dreaded criminal he is being charged with, and he has committed hundreds of murder, and in that case, if you mispronounce a name also, it will he there is a chance that he'll be misled. In such a case, thus such defective charge can be fatal. So my point is, whether it is actually misleading the accused, whether it is prejudicial to the accused, and whether it is causing grave injustice. Those are the parameters which have to be seen to make sure that whether a defective charge will be fatal to conviction or not. Sonali Mahanti is extremely sorry because it was too late to join. It's okay, ma'am. You can please note down the time next time onwards. My bad is that sometimes I take classes at 7 and sometimes it's 5. Due to my so-called busy schedule, I am constrained to make such time changes. Please cooperate. Yes, as you put it, unless it causes prejudice to the accused, then it is a mere technical error. Snigdha Panigrahi rightly writes that. Is there any other question?
Good evening, sir. Sir,
Yes,
actually,
Sakti.
what role does sanction play while taking cognizance in respect of public servants?
In respect of public servants,
Yes, sir.
basically sanction, if without sanction, cannot be the cognizance against public servants cannot be taken. That is the rule. Limitation of on taking power of taking cognizance when it has been fixed. That means without even when a final report is brought, even when a I'm sorry, not final report, even when a charge sheet is brought, then also the magistrate or the court has to wait. So basically, when normally an FIR is sent, the magistrate will write in his order sheet that the FIR is received, then, and then he'll write at the end that awaiting FF, that awaiting final form. But once the final form is received, he should ideally go ahead with taking of cognizance that FF is received on Amuka, and it reveals from the case record and the FIR 161 statements that there is a prima facie case being made out against the accused for the commission of offense. Hence, cognizance not against the person. I'm sorry, cognizance of these offenses are taken. But if the sanction is pending, then the magistrate shall write in his order sheet that FF is received, awaiting sanction. A prima facie case is made out. However, awaiting sanction for taking of cognizance. So without taking cognizance, without getting the sanction, cognizance cannot be taken. If there is a cognizance taken, if that's your question, if it's a cognizance taken even before a sanction is obtained, because the magistrate probably missed it, that will be an illegal order, and that will be vitiating the trial. It will not be an irregular order that can be cured.
Thank you, sir.
Welcome. Any other question? Quickly, if anyone. Otherwise, we'll end it. Is the presence of accused necessary while framing a charge? Of course, it is necessary. Of course, it is necessary. Because the object of charge is to let the accused know about the specific formulation of the accusations that you are putting against him, in order to make him know that these are the charges leveled against you and you have to meet these, or you have to build your defense accordingly. So the presence of the accused cannot be dispensed while framing of charge. He has to be present. But of course, while substance of accusation is being explained in a summons case, what is done is that in that case, the presence of accused can be excused, because it's not a formal charge. In that case, it is less formal in nature. There you can excuse, but not in a warrant case, not in a sessions case. Definitely not. The substance of accusation, while it is being explained, while you are framing the charge, the accused has to be there. It is an indefeasible right of the accused to know about the uh, materials that are brought against him, or offenses that are being leveled against him. Right? So I believe no one else has any question. Right. Let's declare the session closed for now. I hope it was a good one. Have a great evening, and we shall meet again probably next week. I'll let you know the times. Thank you.
Thank you, sir.